welcome to another current affairs video. Today our topic for discussion is Article 356 and Judicial Activism. In the last couple of weeks, several editorials appeared on this topic. Since this is a static topic covered in details in your Lakshmikant, we will take an answer writing based approach today and see how we can frame an answer on this topic. I will provide you with some context as to why this was in news and also give you a model answer. Today's question is: discuss the extent to which Article 356 has provided the scope for judicial activism. Now, evidently, this is part of our GS2 syllabus, and within that we can fit it into the subtopics of Indian Constitution, features and significant provisions, functions and responsibilities of the Union and states, challenges pertaining to federal structure, and functioning of executive and judiciary. Now let us understand the context as to why we are discussing this issue. The story begins on October 1st when the Andhra Pradesh High Court, while listening to a clutch of habeas corpus petitions related to police excesses, ordered the state government to help the court in determining as to whether there has been a breakdown of constitutional machinery in the state. The Andhra Pradesh government, in its appeal to the order, mentioned that the breakdown of constitutional machinery is an executive decision that is based on a factual analysis and it is not meant to be determined by the High Court. When the matter went to the Supreme Court in December 2020, the Supreme Court stayed the order of the Andhra Pradesh High Court and described the intervention of the High Court as deeply disturbing. So the commanding word for today's question is discuss. Now in UPSC, we have several such commanding words like elucidate, explain, critically examine, discuss. So let us see how we should move ahead with the question in hand. When the word is discuss, what we will do is, we will build on the given context with some reasons. We will select some evidence to support the points that we are providing and finally arrive at a conclusion. What is going to be our approach? Now we have identified that the underlying theme today is judicial intervention with respect to Article 356. Within this broader theme, we will see as to how the content of Article 356 has provided the scope for judicial intervention. Finally, we will also refer to some important judgments and some key words that can strengthen our answer. Now, while writing this answer, please avoid referring in details to the provisions of Article 356 without going back to the demand of the question. Second is, the question is not asking for us to provide details about the historical background of judicial activism. Now let us come to the structure of our answer. Firstly, we will provide a context-based introduction. In the body, we will discuss the reasons as to why Article 356 has created the scope for judicial activism. We will further divide this into three subheadings. First, we will discuss that because the use of Article 356 has been driven by political considerations, that has led to judicial activism. Second is, there is some ambiguity in the wording of Article 356 itself that has created the scope for judicial intervention. And last point, we will provide a balanced view and write that judicial intervention is also one of the institutional mechanisms to safeguard the federalism in India. Finally, in the conclusion, we will mention the recommendation of the Sarkaria Commission or the National Commission to review the working of the Constitution. Now let us discuss the model answer that we can write for this question. Our question is, discuss the extent to which Article 356 has provided the scope for judicial activism. Coming to our answer, we can begin with the Supreme Court has recently stayed the interim order passed by the Andhra Pradesh High Court, which had sought assistance of the state government to determine if constitutional machinery had broken down in the state. The apex court described the High Court's intervention as disturbing. This development has revived the discussion with respect to judicial activism in matters of Article 356. You will see here that we have written a context-based introduction. Coming to our first subheading, the use of Article 356 has been guided by political consideration. Article 356 gives wide powers to the state to dismiss elected governments, and it's used to encourage defections from opposition-led governments. This has led to increased judicial activism with respect to Article 356. In 2016, the Uttarakhand High Court had quashed the imposition of President's rule in the state and reinstated the dismissed Council of Ministers. Now, our second subheading is ambiguity in Article 356 has created the scope for judicial activism. Now, you are aware that subclause 1 of Article 356 reads that if the President, on receipt of a report from the Governor of the state or otherwise, is satisfied that the situation has arisen wherein the government of the state could no longer be carried on in accordance with the provisions of the Constitution. Now, the word otherwise in subclause 1 of Article 356 is left undefined. Hence, it is not clear if the finding or observations of courts can be a basis for invoking Article 356. This creates the scope for judicial intervention and thereby leads to dilution of separation of powers. The threat of imposition of President's rule is used by the courts to discipline a state government. So what you see here is that we have divided the body into three subheadings. The third one I'll discuss in the next slide. And we have given examples and references to constitutional provisions to support our arguments. Now coming to our third subheading, Judicial Safeguard is one of the institutional mechanisms that has strengthened the federal spirit in India. Judicial intervention with respect to Article 356 has been crucial in protecting constitutionalism. Now, what is constitutionalism? Constitutionalism means limited government and abiding by rule of law as opposed to totalitarianism and authoritarian government. Coming back to the answer, the Supreme Court has created immunity for the state government against the arbitrary use of Article 356 through the S.R. Bommai case. The apex court reiterated the power of the judiciary to refute the malified nature of presidential satisfaction and illustrated some situations that do not amount to failure of constitutional machinery. Now you can see here that we have mentioned landmark judgment, the S.R. Bommai case, and also used important keywords like constitutionalism. Now coming to the conclusion for our answer, I have included here the recommendation of the National Commission to review the working of the Constitution, as the Sarkaria Commission recommendation are already provided in your Lakshmika. So let us read their conclusion. The National Commission to review the working of the Constitution had recommended that Article 356 be used sparingly. It recommended that President's rule should be proclaimed on the basis of a Governor's report. The Governor's report should be a speaking document containing all material facts and grounds on the basis of which the President may satisfy himself as to the existence or otherwise of the situation contemplated in Article 356. So you can see here that we have provided a conclusion that is based on a committee report. So since we took a static topic today, I hope that you will read the relevant chapters from Lakshmikant and D.D. Basu. I hope that what you have learned from today's video is how we can use our static and current affairs knowledge to write a good answer. Please keep in mind that the different GS papers require us to use a vocabulary that is suited to that paper. So when you're writing a GS2 answer, please make reference to constitutional provisions and landmark judgments. So that's all from my side today, and I hope you enjoyed watching the video. Thank you.